July 5 Indian Express news article. Let us see in this video. First article is related to no service charges by default. Government tells hotels and restaurants. You have to know what to read as what is Consumer Protection Authority and its recent guidelines. Okay, Central Consumer Protection Authority on Monday barred the hotels and restaurants from adding service charges automatically or by default in the food bill. It said that in case of violation, a consumer can ask the hotel a restaurant to remove the service charge or seek redressal by filing a complaint. The guideline issued by Central Consumer Protection Authority stipulate that hotels or restaurants shall not add service charge automatically or by default in the food bill. No collection of service charge shall be done by any other name. No hotel nor restaurant shall force the consumer to pay the service charge and shall clearly inform the consumer that service charge is voluntary, optional, and at consumer's discretion. Service charge shall not be collected by adding it along with the food bill and levying GST on total amount. This is what this article talks about. And also, the consumer may lodge a complaint on the National Consumer Helpline, which works as an alternate dispute redressal mechanism at the pre-litigation level by calling 1915 through the National Consumer Helpline mobile app. Next article talks about government stills to clear 26 as judge. Bombay High Court down to nearly half its strength. You have to know what is collegium system, how did it evolve, what are the procedures for judicial appointments, what is critical about collegium system, what are the attempts to reform the appointment system, and what lies ahead. These are all the points you have to know from this article from the Lakshmikant static portion. Let us see what the article talks about. 26 recommendation for the appointment of judges to the Bombay High Court, which is currently functioning at almost half of its sanctioned strength, are pending with the government at different stages of consideration. Bombay High Court currently has 57 judges against a sanctioned strength of 96 judges. At least 5 more judges are expected to retire this year. The appointment process begins with the High Court Collegium processing a name. It is then sent to government for inputs of the CM, Governor and IB. With all the inputs, Ministry of Law and Justice then places the file before the Supreme Court Collegium for consideration. This is what the article talks about. Next article that we are moving into is all about PM hails Digital India, transparency ending network for middlemen. From this article, what are the key takeaway means? You have to know what is Digital India program, vision areas and the objectives and the significant achievements. Let us see what the article talks about. In the last 8 years, more than 23 lakh crore has been transferred through direct benefit transfer to beneficiaries. Due to this technology, Digital India campaign has helped 2.425 lakh crore from falling into wrong hands in the past 8 years. Prime Minister Narendra Modi said. He said that trio of Jantan, Mobile Aadhaar and JAM, that is provide maximum benefits to the poor and middle class. Cowin and Arogya Setu are two mobile applications that help it provide 2 crore vaccine doses. He said India's UPI has been appreciated by World Bank. The next article that we are moving is related to Prime Minister New India must reflect the dream of freedom fighters. He says. This is all about Alluri Sita Rama Raju, who is called whose birthday is 125th anniversary, not birth, birth anniversary of legendary freedom fighter Alluri Sita Rama Bhimavaram in Godavari district is celebrated. On this gathering, Modi told New India should be an India of their dreams. Such India where the poor and farmers and workers and backward classes and Adivasis, the oppressed all have equal opportunities. Next article talks about let deemed cities call themselves universities. House panel tell governments. The parliamentary panel has urged the government to actively consider the following deemed universities in the country to use the term university to avoid confusion abroad, and as most foreign countries do not use such a nomenclature. In its report, Parliamentary Standing Committee on Education, Women, Child, Youth and Sports have recommended the amendment of Clause 23 of UGC Act 1956 to let the deemed universities to drop the prefix. The committee recommends the government given an active consideration to the demand that deemed universities be allowed to use the term universities by amending Clause 23 of the UGC Act 1956, which states that no institutions other than universities established or incorporated by central act or provincial act or state act is entitled to use the word university. Academic environment in deemed and private universities, other higher education institutions also make a strong pitch for streamlining the accreditation process of higher education institutions. Next article is all about Raja heated pitch on separate Tamil Nadu, autonomy sets on fairy row. DMK MP, ex-Union Minister A. Raja has sparked controversy by asking BJP ruled centre not to compel the Dravidian party to revive the demand for separate Tamil Nadu by denying state autonomy. Tamil Nadu contributes 10% of nation's overall GST income as well as 6.5% of total revenue, tax revenue. Nonetheless, the national financial returns it gets from the center is less than 1.2%, which is unfair for federal system. The article says. The next article talks about bench above religion. Judges have been fair and sensitive to Muslim cause. Muslim women in particular have had more success. The article talks about conduct a project on contribution of Muslim judges to Indian legal system. Do not have Muslims or non-Muslim judge in India. Our judges are ideologically neutral. Unlike in US where there are Republican and Democrat judges, that does not mean the question about inclination of judges have not been raised in the past. On June 20th, Justice D.Y. Chandrachud was asked about the judiciary treatment of Muslims at King's College London. In this writer's view, our judge do not have the litigant religious identity in mind while dispense justice. Last week, Justice Suryakant and Justice J.B. Pardiwala made scathing observation against ex-BJP spokesperson Nipun Sharma for asking against Prophet. Justice Suryakant blamed her for the tragic killing in Udaipur. Unfortunately, the remark of the judge have drawn criticism though the real intention was merely to end the controversy, improve our international image, and give a much-needed healing touch to the Muslims. In 2021, on Wasim Rizvi filed a petition seeking the deletion of 26 so-called controversy verses of Quran. The Supreme Court not only refused to admit this petition but came down heavily on the petitioner and imposed a fine of 50,000. In 1984, another petition in Calcutta High Court met with a similar fate. It is true that many young Muslims had been arrested on terror charges under the successive government, but the accused in many cases, such cases are acquitted, clearly demonstrate that ordinary Muslim litigants have been getting justice from other judges. Even in the Ram Janmabhoomi Babri Masjid case, Supreme Court termed the installation of idols in 1949 and demolition of Babri Masjid in 1992 as rigorous wrong. It had also observed that Places of Worship Act 1991 protects and secures the fundamental values of the Constitution. After Babri Masjid demolition, Supreme Court in S.R. Bommai 1994 upheld the dismissal of BJP government in Madhya Pradesh. In the privacy judgment, the apex court talked about the culinary freedom and freedom to dress. As a result, several laws put restrictions on beef eating can now constitutionally re-examined. Between in Tassin S. Poonawalla 2018, it came down heavily against mob lynching and asked the parliament to enact a law against such activities. Even in the Triple Talaq verdict 2017, the majority deemed triple divorce to be void because the Quran does not mention it and pointed out what is sinful in theology cannot be valid in law. 30 related jurisprudence on right of minorities to establish and administer educational institution. In Article 30, it has held that the term institution would include the universities and its use of the word choice, which makes it right and expansive one. The court was consistently had held that government aid cannot come with the conditions that affects the minority character of the institution. Ahmed St. Xavier College 1974, Justice K.R. Khanna observed that minorities are as much the children of the soil as the minority. The approach has to ensure that nothing should be done as might deprive the minority of the sense of belonging. Any matters referred to Constitution Bench does not take 4 to 5 years. That explains the delay in hearing petitions related to CAA and Article 370. But the judiciary disapproved of the heavy penalties on CAA protesters in UP. Thus, our judges have not only fair but also quite sensitive to Muslim cause. In fact, Muslim women in particular have had much more success before the judiciary than Hindu women. Muslims have full faith in our judiciary and do not need the Organization of Islamic Cooperation or any other foreign agencies to take up their causes. This is what the article talks about. Let us continue the next article in the next video. Thank you. Have a nice day.